South Mississippi community is in mourning tonight after a body was found in the water on Horn Island.
The family of 18-year-old Nolan Wells, who was last seen Saturday afternoon, sharing posts on social media confirming their loss.
Two cases are forming, and only one of them belongs to the district attorney. Attorneys for the Wells family have outlined their next steps, and litigation is expected, per Mississippi Public Broadcasting. That is a civil case, a different court, a different standard of proof, and a different set of doors. It does not need an indictment. It does not need a grand jury. It runs on its own timetable. And it explains the last 3 weeks. The subpoenas to 5 tech platforms, the subpoenas to the marine towing companies, the insistence on a joint phone examination. Those are not a family waiting. That is a family building a file. Here is where the record gets very narrow, very clean, very short. That is the floor. Everything else builds from there. Here is what is actually in the official record right now. On the 20th of August, Christine Wansley filed subpoenas seeking marine towing records. The window they cover runs from 2 p.m. to 8 p.m. on the 4th of July. The records requested include calls, recordings, and dispatch logs. That is per TMZ. Think about that window. 2 p.m. to 8 p.m. That is the entire afternoon, the trip, the return, the hours after. The subpoena pulls the full day from those companies. Those towing records are new, they are specific, they are aimed at the marine side of the timeline most of us cannot see. Now the phone. Ben Crump said on the 17th of August the family is ready for a joint forensic phone inspection, per WLBT. Not a request, not a hope. Ready. That is a statement of position from the family's attorney. And here is the legal context that makes all of this make sense. A civil claim proceeds on a lower standard of proof than a criminal prosecution, and it does not require an indictment. That is basic court structure. So the family is not waiting on the district attorney's timeline, they are building their own. The district attorney, Angel Myers-McElrath, has said all evidence in the criminal investigation stays sealed until it is presented to a grand jury. That is per NOLA.com. Sealed. Until the grand jury. That could be weeks. That could be months. That is the criminal case clock, and it is not moving on anyone else's schedule. The civil case has no such lock. No sealing order stops a subpoena in Chancery Court. No grand jury gate keeps the evidence out. The standard of proof is lower. The doors open sooner. So you have 2 tracks running side by side. The criminal investigation, sealed, going toward a grand jury. The civil investigation, public filings, subpoenas, moving now. Here is what is confirmed. The subpoenas to the marine towing companies, the subpoenas to the 5 tech platforms, the joint phone inspection the family says it is ready for. Here is what is not confirmed. Anything from inside the criminal file, anything from the autopsies, anything from the phones, all of that is sealed. The family's attorneys have outlined next steps. Litigation is expected, per Mississippi Public Broadcasting. Expected. That word is doing a lot of work. It means the filing is coming, not filed yet, coming. So the confirmed record right now is a list of legal actions, subpoenas filed, a joint inspection agreed to in principle, a civil case that does not need a grand jury to move forward. That is the entire confirmed list. It is short, it is specific, and it is aimed at one thing, the phone. And that is where the 2 cases collide, because the criminal investigation has the phone. The evidence is sealed, and the family is ready to open it together. But while the official record stays locked, another record is moving. It does not live in a courthouse. It lives online. A document is circulating. It claims to be a toxicology report for Nolan Wells. And the state's public safety commissioner, Sean Tyndall, has a word for it. Fraudulent. That is per the Mississippi Department of Public Safety, via WLBT, from late July. Not disputed, not incomplete, fraudulent. The commissioner is saying the document itself is not genuine. A toxicology report tests a body for drugs and alcohol. It is a lab document. It has a chain of custody, and this one, according to the state, is not real. Now hold that against the official record. The state's own autopsy was finished by the 31st of July. Its findings have not been released. They are headed to a grand jury. Per LOP, so if a toxicology report is moving around online, it cannot be coming from the official file. That file is locked. That is the space the public is living in right now. A sealed file nobody can see. A circulating document the state says is fake, and nothing in between. So let us do what this beat is actually for. Name what is circulating. Name where it comes from. Stop there. The toxicology report. Circulating. Called fraudulent by the state's own public safety commissioner. Source: the Mississippi Department of Public Safety via WLBT. That is the sharpest object in the unverified pile, and it is the one the state has told you to ignore. Because here is the reality of this case. The verified record is small. Subpoenas. An agreed phone inspection. A civil case that does not need an indictment. That is the confirmed list. The circulating record is louder. A report the state calls fake. Speculation about the young men who were on the boat. None of them charged. None of them named as suspects. And a case file that is, by law, invisible until a grand jury sees it. Loud does not mean true. In this case, the loudest thing is the one the state has directly called fraudulent. So when you see a post about Nolan Wells's toxicology results, run the source check yourself. The state autopsy is sealed. The findings go to a grand jury. There is no public toxicology report. The one being shown to you is, per the state's commissioner, not genuine. That is the whole check. It takes 10 seconds. Identification. Source. That is the whole of what is verifiable in the noise. But underneath the noise, the verified record is moving. It is not moving fast. It is moving on a clock. Those platform subpoenas gave the companies 21 days to preserve and produce records to the petitioner's counsel. Per the Atlanta Black Star, 21 days. 3 weeks. A deadline that does not depend on the grand jury at all. It depends only on a filing in Chancery Court. The filings went to Jackson County Chancery Court, inside the probate proceedings, a civil track, running parallel to the criminal one, per the Atlanta Black Star. Preserve means hold everything. Do not delete, do not overwrite. Produce means hand it over. That is a legal instruction, on paper, with a clock attached. And the towing subpoenas are part of the same build, marine towing records, per TMZ, filed on behalf of Nolan's mother. The civil track is not waiting for anyone. So while the speculation runs hot over a document the state calls fraudulent, the actual record is being assembled, subpoena by subpoena, day by day, 21 days at a time. That is the quiet engine of this case. Not the noise, the filings. The criminal file is sealed, the civil file is not, and the civil file keeps growing. The question is what happens when the records start arriving. What the towing companies captured on their dispatch lines. What the platforms preserved before the deadline. What is actually on that phone. Those are the questions the subpoenas were built to answer, and the answers are still sealed. That is when the case stops being rumor and starts being evidence. The document the state calls fraudulent traveled further than the sealed autopsy ever could. That is the strange arithmetic of this case. The real record is invisible, the fake one is free, so the fake one wins the race. Here is who said so. Mississippi Public Safety Commissioner Sean Tindell, per WASO, warned that a purported toxicology report circulating on social media is not genuine, not disputed, not unverified, not genuine. One official sentence about a document strangers keep posting. The real autopsy is the one you cannot see. The fake one has no such problem, the space filled with the only document people could actually open. And that document did not travel alone. It carried a story with it. A story about the 3 young men who were on that boat. The report and the rumor moved as one. Per CNN and NPR, no one has been charged in Nolan's death. That fact did not survive the first share. It died in the comments. Those young men have reported death threats and online harassment, per WWL and ABC News. One friend's attorney has sent a cease and desist letter. And the FBI is investigating threats against the people who were with Nolan Wells in the hours before he vanished, and against officials working the case, per Live Now from Fox. That is what the fake document did. It did not just misstate a lab result, it turned witnesses into targets. It took a sealed investigation and wrote a verdict on it. A verdict nobody had the authority to write. It wrote one anyway. Here is how the two got mixed. The fake report and the real investigation. They look the same on a timeline. Same case. Same names. Same afternoon. People share the screenshot as if it were the autopsy. The autopsy is sealed, so nobody can check. The lie borrows the authority of the real case. That is the mixing. The real investigation has a paper trail. Subpoenas filed in Jackson County Chancery Court. A 21-day deadline. A court you can look up. An agency you can call. A docket number that exists. The fake has none of it. No file number, no court. No letterhead you can verify. Just a screenshot, a caption, and a share button. No court stamp. No case number. No signature you can trace. So the check is one question. Where does this document live? If it lives in a courthouse, you can find it. If it lives only in a post, you already have your answer. You can run it in 10 seconds. Faster than the toxicology post took to load. That is the whole media literacy lesson. It is not complicated, it is one question. Sit with that question the next time the post arrives. What court filed this? What agency issued it? If the answer is a screenshot of a screenshot, you are done. The check took less time than the share. And the reason the two got mixed is structural, not accidental. The criminal evidence is sealed by law. The district attorney has said everything stays sealed until a grand jury sees it, per NOLA.com. So the only document circulating in public is the one the state says is fake. The silence creates the space, the fake fills it. The fake answers the loudest question, what happened, with a lie. The real record answers the quiet questions, who, when, where, with paper, subpoenas, towing records, platform data. The loud question has no deadline, the quiet ones do. 21 days. That is the difference between noise and record. Noise has no clock, the record does. And the civil file is not sealed. It is not waiting on the grand jury. It is arriving, subpoena by subpoena, day by day. And there is one piece of that record both sides agreed to open together. The one document that could settle the timeline. The one the family's attorney says they are ready for, per WLBT. The phone. The confirmed record is narrower than the noise, but it is not empty. Start with the timeline. The last time anyone independently verified seeing Nolan Wells fell between 3:23 and 4:27 that afternoon, per the United Cajun Navy's report, a volunteer document and not an official finding. GPS data held by CBS News puts the boat leaving Horn Island at 4:31. That is a window, then a departure. The gap between the last verified sighting and the boat pulling away is measured in minutes, not hours. 4 minutes, by the arithmetic. The boat leaves at 4:31. The sighting window closes at 4:27. That 4-minute gap is the whole case. Now the subpoenas. The mother's attorney filed for marine towing records covering 2 p.m. to 8 p.m. on July 4th, per TMZ. Calls, recordings, dispatch logs. That is a 6-hour sweep around a 4-minute gap. The request is precise. Someone is asking the towing company what happened in the window they do not have. Not the whole day. The window. The platform subpoenas go wider. Meta's Facebook, Instagram, and WhatsApp, plus TikTok, Snapchat, and Life360, filed in Jackson County Chancery Court, per the Atlanta Black Star. 21 days to preserve and produce. Location data, private messages, deleted posts, video from the day. These are the records that do not lie. A person can misremember. A phone records. The autopsies do not explain it either. The family's independent autopsy returned a cause and manner of death of undetermined pending investigation, per ABC News and CNN. The official state autopsy was completed by July 31st, its results sealed, going to a grand jury, per WLBT autopsies. Neither one has given the public an answer. One says undetermined, the other says nothing at all. The criminal case stays sealed by law. The district attorney has said everything remains sealed until a grand jury sees it, per NOLA.com, and no one has been charged, not one person. The sheriff's office has interviewed more than 60 witnesses, per Sheriff John Ledbetter via locks. 60 people, and still no charge. The FBI is assisting with digital evidence because Horn Island sits on federal land. 60 witnesses, federal involvement, 2 autopsies, and the record stays closed. So what does the confirmed set alone imply? Not guilt, not innocence, neither. What it implies is that the physical and digital record has not yet answered the central question. The autopsies could not establish a cause. The boat's departure time is known, but not what happened in the minutes before it. The witnesses have been interviewed, but the evidence from their phones has been requested, not yet produced. The 21-day clock is still running. The civil case proceeds on a lower standard than the criminal one, per general court structure. It does not require an indictment. It does not require the grand jury. It requires a preponderance. More likely than not. That is the bar. And the civil record is not sealed. It is building in open court, subpoena by subpoena. Here is what the confirmed record actually implies. The investigation is not stalled. It is waiting on evidence that has been formally requested. The towing records. The platform data. The phone. Each request is a step toward the same thing. A complete timeline of the minutes no one has explained. The 4-minute gap. The window. The departure. The confirmed set says the case is moving toward one document. The one both sides agreed to open together. The family's attorney said they are ready for it, per WLBT. The forensic download, watched by experts for both sides at the same time. The phone. The family's attorneys have outlined the next steps, and litigation is expected, per Mississippi Public Broadcasting. Not speculation, not a press conference promise, a stated plan of action. And at the center of it, that one device, the phone. Here is the question the whole case keeps circling. What is on it? Ben Crump said on August 17th that the family is ready for a joint forensic phone inspection, per WLBT. Ready. That word matters. Both sides agreed to open the phone together. A forensic download, watched by experts for the family and for the state. The family says they are ready. The record does not say the other side has agreed to a date. It does not say the download has happened yet. It says ready. And the subpoena trail is widening. Christine Wansley, Nolan's mother, filed subpoenas seeking marine towing records covering 2 p.m. to 8 p.m. on July 4th, per TMZ. Calls, recordings, dispatch records, the exact hours of the afternoon in question, the window, the gap, the departure. The towing company's files would show the movements of the boat, not what happened on it, what happened to it. Those subpoenas sit alongside the earlier ones. The 5 platforms, Meta's Facebook, Instagram and WhatsApp, TikTok, Snapchat, Life 360, filed in Jackson County Chancery Court as part of probate proceedings, per the Atlanta Black Star, 21 days to preserve and produce. That clock is running. Location data, private messages, deleted posts, video from the day. These are the records that do not lie. A person can misremember. Phone records. So here is where the open questions stack up. What did the boat's towing records show between 2 and 8? What did the phone's location data show in the 4 minutes that no one has explained? What did the messages say in the 64-minute window before the boat left the island? The civil case does not need the grand jury. It proceeds on a lower standard, per general court structure. More likely than not, it does not require an indictment. It requires evidence. And evidence is being gathered, subpoena by subpoena, in open court. The criminal case stays sealed. The district attorney has said all evidence stays sealed until a grand jury sees it, per NOLA.com. And no one has been charged, not one person. The sheriff's office has interviewed more than 60 witnesses, per Sheriff John Ledbetter via locks, 60 people. Federal involvement because Horn Island sits on federal land. The autopsies could not establish a cause. One says undetermined. The other says nothing at all. The confirmed record is narrower than the noise, but it is not empty. It is a series of formal requests. Each one a step toward the same document, the phone, the one object that could hold the minutes no one has explained. The civil case is building in public. The subpoenas are a matter of court record. The towing records have been requested. The platform data has been requested. The family says they are ready for the inspection. The 21-day clock is running. The next step is not a rumor. It is a filing. It is a subpoena. It is a date for a forensic download. And underneath all of it is a person. Nolan Wells was 18 years old. He went on a boat trip to Horn Island on July 4th. He did not come back. His body was recovered on July 6th. per CNN and Deluxe. A 4th of July trip, a holiday, a group of friends, a boat, and an 18-year-old who did not come home. The phone is not the story. The phone is a tool, a record, a witness that cannot misremember. The story is a mother who keeps filing, who keeps requesting, who says she is ready, a mother who wants to know what the records show about her son's last hours. The subpoenas are the questions. The phone is the answer. And the answer has not been read yet. There is one more thing worth saying plainly about a civil case, because it is the part people get wrong. A civil claim does not need a prosecutor to agree with it. It does not need a grand jury to vote. It does not need anyone to be arrested first. It runs on a lower standard of proof and on its own calendar, and it opens doors a criminal file keeps shut. Depositions taken under oath, documents produced on a deadline, witnesses answering questions in a room with a court reporter present. That is what the last 3 weeks have been building toward. Not a verdict, access. And look at the shape of the requests once you read them that way. 5 technology platforms, Meta's Facebook, Instagram, and WhatsApp, plus TikTok, Snapchat, and Life360, each given 21 days to preserve and produce, per Atlanta Black Star. Then the marine towing companies asked for 6 hours of calls, recordings, and dispatch records, covering 2 in the afternoon to 8 in the evening on the 4th of July, per TMZ. Then the phone, and an insistence that it be opened jointly rather than by one side alone. Those are not 3 unrelated moves. That is a file being assembled in the order a lawyer assembles one. First, preserve what can disappear, then collect what an institution already keeps, then secure the single object everyone agrees matters most. Preservation first, because a platform that is never asked has no duty to keep anything. Records second, because a company that runs on logs cannot later say the logs never existed. The phone last, because it is the piece both sides will fight over hardest. Who any of it might be aimed at is not something anybody has said, and it is not something to guess at here. No one has been charged in connection with Nolan Wells's death.